In the case of the County of Butler et al. Versus Thomas Wolfe, the District Court for the Western District of Pennsylvania was asked to decide if Governor Wolfe's lockdown and shutdown orders violated the Constitution of the United States. While much of the analysis and reasoning Judge Stickman used was constitutionally flawed, he did come to a constitutionally sound conclusion. So we'll discuss that next, right here on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and study the Constitution, and we teach the rising generation to be free. I am so glad you could join me. I've got a very interesting article, but before we head there, please, I'd love you to head over to the website, constitutionstudy.com. Find out more about how you can engage, not only how you can learn, but how you can share what you've learned with others. You look at the world around us right now, and well, it's pretty much crazy. But it's amazing when we go back to the Constitution where it actually says how many answers we find there, how much we can defeat the crazy. So please head over to that website. Everything on the website is free. It is there for you to use. It is there for you to share. It is there for you to engage with others. I'm also, by the way, on Facebook, YouTube, Rumble, Parler, Twitter. I'm all over the place. But if you want to help keep this going, you might consider signing up for the newsletter. It's where I announce all my new classes, my new events. They're always up there. You may even consider donating to cause. Help keep the Constitution Study podcast going. Help keep it free. Help keep it as a resource you can use to educate yourself and to share with others. And speaking about educating ourselves, let's take a look at this case out of Pennsylvania. Now, as with most cases of this type, I am frustrated with the repeated attempts to use the First Amendment of the United States Constitution against the states. Now, the first 5 words of that amendment clearly state that it applies to the actions of Congress and thereby the federal government. Quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and to petition the government for a redress of grievances. Now, I've also come to expect judges at both the state and federal level to place the opinions of their fellow justices above even the supreme law of the land. And Judge Stickman sadly did exactly that. Now, while reviewing this case, I found numerous instances of flawed jurisprudence, but was pleased to find that Judge Stickman did actually come to the constitutionally sound conclusion that Governor Wolfe's orders violated the 14th Amendment to the Constitution. Now, in this case, there were 3 groups of plaintiffs: the county group, the political group, and the business group. And they all sued Governor Wolfe in civil court, listing 5 counts of violations under 42 U.S.C. 1983, claiming violations of the First Amendment, along with the due process and equal protection clauses of the 14th Amendment. Now, one of the counts claimed a violation of the Takings Clause of the Fifth Amendment, but that was not covered in the opinion. Now, the county group was found not to have standing. Since counties are creations of the state, they are not parties to the Constitution of the United States. They do not possess the rights protected by that document. The political and business groups, however, well, they did have standing. Now, the fact that they sued under 42 U.S.C. 1983 is important, I believe, for 2 reasons. See, first, while the plaintiffs are claiming Governor Wolfe violated the Constitution, they did not claim he did anything criminal. That means that while the court could find for the plaintiffs, there would be no direct consequence for Governor Wolfe himself. My guess is this is the second reason why they chose this route, because it is easier to win a civil case than a criminal one. See, if they had pressed criminal charges under 18 U.S.C. 242, the deprivation of rights under color of law, they would have had to prove beyond a reasonable doubt that Governor Wolfe had willingly subjected them to the deprivation of rights protected by the Constitution under the color of law. Now, while winning under 42 U.S.C. 1983 is easier, I believe it will take several government officials being charged under 18 U.S.C. 242 for them to realize that the American people will no longer stand for their illegal behavior. Let's start by looking at the state's police powers claimed by the Commonwealth of Pennsylvania. Quote, Defendants contend that the gathering limits pass constitutional muster because they are legitimate exercises of the defendant's police power in an emergency situation and are content neutral. They contend that even in a traditional public forum, the government may impose content-neutral time, place, and manner restrictions, provided that the restrictions are justified without reference to the content of the regulated speech, that they are narrowly tailored to serve a significant government interest, and that they leave open ample alternative channels for communication of the information. Now, one of the reasons the Federalists opposed the creation of the Bill of Rights back in 1787 was the fear that someone would claim the authority to regulate them if they were actually written down. This idea that a state's police power gives them the authority to violate someone's rights as long as they are content neutral and justified is in direct contradiction to the language of the Constitution. Quote, under the First Amendment jurisprudence, a non-content-based restriction is not subject to strict scrutiny, but still must narrowly tailor to serve a significant government interest and leave open ample alternative channels of communication. This is from Perry. Here, the court credits the fact that defendants' actions were undertaken in support of a significant government interest managing the effects of the COVID-19 pandemic in the Commonwealth. The congregate limitations fail scrutiny, however, because they are not narrowly tailored. The Supreme Court explained that the requirement of narrow tailoring is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation. That comes from Ward. Now, if the First Amendment actually applied to the states, the current First Amendment jurisprudence is a perfect example of placing the opinions of judges above the language of the law. Why? Because the First Amendment reads, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably assemble, and to petition the government for a redress of grievances. Notice that the First Amendment doesn't say Congress shall make no law, well, unless there's an emergency, or unless it is needed to fulfill a significant government interest. In fact, I contend there's only one legitimate, significant, or as it's more often stated, compelling government interest, that of protecting the rights of the people. This comes directly from the Declaration of Independence. Quote, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Next, let's take a look at the due process arguments. Quote, plaintiffs assert that the components of defendants' orders closing, quote, non-life sustaining businesses and imposing a lockdown violated their liberties guaranteed by the Due Process Clause of the 14th Amendment. Substantive due process is not an independent right, but rather a recognition that the government may not infringe upon certain freedoms enjoyed by the people as a component of a system of ordered liberty. Here, plaintiffs assert two grounds whereby defendants' orders violated substantive due process: in the imposition of a lockdown and in their closure of all businesses that they deemed to be non-life sustaining. Now, it's interesting because the Constitution doesn't mention substantive due process, or as was also commented, the procedural due process. Just plain due process. As we read from the 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. There's no substantial due process or procedural. There's just due process. So what is this due process? Well, according to Webster's 1828 dictionary, due is an adjective meaning owed, that ought to be paid or done to another. That is due from me to another, which contract, justice, or propriety requires me to pay, and which he may justly claim as his right. And process is a noun. In law, the whole course of proceedings in a cause, real or personal, civil or criminal, from the original writ to the end of the suit. Or as the Free Legal Dictionary Online states, that due process is an established course for judicial proceedings or other government activities designed to safeguard the legal rights of the individual. Now, rather than diving into the swamp of judicial opinions, what the court should have been asking itself is, was Government Wolf following a process that safeguarded the legal rights of the individual citizens of the Commonwealth of Pennsylvania? Quote, plaintiffs argue that the lockdowns effectuated by the stay-at-home orders violated their substantive due process rights secured by the 14th Amendment. They contend that the orders do not impose a traditional disease control measure, such as quarantine or isolation, but rather involuntarily and without due process confine the entire population of the Commonwealth to their homes, absent a specifically approved purpose. Plaintiffs contend that the lockdown violated their fundamental right to intrastate travel and their freedom of movement. Plaintiffs further argue that while the power to involuntarily confine individuals is generally strictly limited by law, defendants' lockdown was overbroad and far exceeded legitimate government need and authority. They conclude that even compelling state interests cannot be pursued by means that broadly stifle fundamental personal liberties when the end can be more narrowly achieved. The proper argument from a constitutional standpoint is not whether the act is too broad. Instead, government is forbidden from depriving people of their life, liberty, or property without due process of law. Period. No exceptions. Since the act applied to everyone, not just those who could possibly be a danger to others, and since there was not even an attempt made to seek legal justification for the effective house arrest of the people of the Commonwealth, not only was due process not followed, but the state claimed the authority to throw out at least parts of the constitutions of both the Commonwealth of Pennsylvania and the United States of America, just because they said, we need to. Next, Judge Stickman gets into the question of lockdowns. Quote, defendants attempt to justify their extraordinary mitigation efforts by pointing to actions taken to combat the Spanish flu pandemic a century ago. Ms. Boateng testified that in response to the Spanish flu, quote, much of the same mitigation steps were taken then. The closing of bars, saloons, cancellation of vaudeville shows, as they called them, and cabarets, and the prohibition of large events. So some of these same actions that were taken now had been taken in the past. But an examination of the history of mitigation efforts in response to the Spanish flu, by far the deadliest pandemic in American history, reveals that nothing remotely approximating lockdowns were imposed. Now, Ms. Boateng, the Executive Deputy Secretary of the Pennsylvania Department of Health, claims that the actions taken by Governor Wolf and his administration are nothing new. Judge Stickman noted that that's far from the historic truth. In fact, he went on to make an interesting comparison of the reactions many in this country have taken in response to COVID-19. Quote, the fact is that the lockdowns imposed across the United States in early 2020 in response to the COVID-19 pandemic are unprecedented in the history of our Commonwealth and our country. They have never been used in response to any other disease in our history. They are not recommendations made by the CDC. They were unheard of by the people of this nation until just this year. It appears as though the imposition of lockdowns in Wuhan and other areas of China, a nation unconstrained by concerns for civil liberties and constitutional norms, started a domino effect where one country and state after another imposed draconian and hitherto untried measures on their citizens. The lockdowns are, therefore, truly unprecedented from a legal perspective. Judge Stickman points out that these lockdowns across the country, well, they look more like something coming out of communist China or some other dictatorship that's unconcerned with your rights and liberties, well, rather than coming from the land of the free and the home of the brave. Now back to the judge's opinion. Quote, the stay-at-home orders far exceed any reasonable claims to be narrowly tailored. Defendant's orders subjected every Pennsylvanian to a lockdown where he or she was involuntarily committed to stay at home unless he or she was going about an activity approved as an exception by the orders. Even in the most recent and currently applicable iteration of defendant's orders, while the operation of the stay-at-home provision is suspended, it is not rescinded and may be reimposed at any time at the sole discretion of the defendants. Thus, defendants' orders have created a situation where the default position is lockdown unless suspended at their will. When in place, the stay-at-home order requires a defendant to confinement at home unless a citizen is out for a purpose approved by the defendant's orders. Moreover, this situation applied for an indefinite period of time. This broad restructuring of the default concept of liberty of movement in a free society eschews any claim to narrow tailoring. Judge Stickman is looking to satisfy the opinions of previous courts that allow an infringement of rights for sufficient government interests, as long as it's narrowly tailored. However, he can't find anything narrowing or limiting, much less one that would comply with the prohibitions included in the supreme law of the land. Going on, the court declares, therefore, that the stay-at-home components of the defendant's orders were and are unconstitutional. Broad population-wide lockdowns are such a dramatic inversion of the concept of liberty in a free society as to be nearly presumptively unconstitutional unless the government can truly demonstrate that they burden no more liberty than is reasonably necessary to achieve an important government end. The draconian nature of a lockdown may render this a high bar indeed. After the lockdowns, Judge Stickman looks at the shutdown order. Quote, as with the lockdown, defendant's shutdown of all non-life sustaining businesses is unprecedented in the history of the Commonwealth and indeed the nation. While historical records show that certain economic activities were curtailed in response to the Spanish flu pandemic, there has never been an instance where a government or agent thereof has sua sponte divided every business in the Commonwealth into two camps, life-sustaining and non-life sustaining, and closed all the businesses deemed non-life sustaining unless that business obtained a discretionary waiver. As with the lockdowns, the shutdowns of the businesses on this scale is unprecedented. While the plaintiffs claim this was a violation of their liberty, it's also a violation of their property. From an essay James Madison published on the topic of property, quote, that is not a just government, nor is property secure under it, where arbitrary restrictions, exemptions, and monopolies deny to part of its citizens that free use of their faculties and free choice of their occupations, which not only constitute their property in a general sense of the word, but are the means of acquiring property strictly so called. If there be a government, then, which prides itself in maintaining the inviolability of property, which provides that none shall be taken directly, even for public use without indemnification to the owner, and yet directly violates the property which individuals have in their opinions, their religion, their persons, and their faculties, nay more, which indirectly violates their property in their actual possessions, in the labor that requires their daily subsistence, and in the hallowed remnant of the time which ought to relieve their fatigues and soothe their cares, the influence will have been anticipated that such a government is not a pattern for the United States. As Judge Stickman noted previously in his opinion, these are the tactics of a tyrannical government, not those of public servants of free people. I believe Judge Stickman brought the matter to a fine and eloquent point in his conclusion. Quote, the court closes this opinion as it began, by recognizing that the defendant's actions at issue here were undertaken with the good intention of addressing a public health emergency. But even in an emergency, the authority of the government is not unfettered. The liberties protected by the Constitution are not fair weather freedoms, in place when times are good, but able to be cast aside in times of trouble. There is no question that this country has faced and will face emergencies of every sort. But the solution to a national crisis can never be permitted to supersede the commitment to individual liberty that stands as the foundation of the American experiment. The Constitution cannot accept the concept of a new normal, where the basic liberties of the people can be subordinated to open-ended emergency mitigation measures. Rather, the Constitution sets certain lines that may not be crossed even in an emergency. Actions taken by defendants crossed those lines. It is the duty of the court to declare those actions unconstitutional. This blatant violation of the most basic tenets of a constitutional republic is so egregious. I hope the people of the Commonwealth not only remove Governor Wolf as soon as legally possible, but that they press federal charges under 18 U.S.C. 242. For that matter, I hope citizens in every jurisdiction who is or has suffered under these despotic lockdown, shutdown, and mandatory mask orders will rise up, press charges, and remove from office those vile dictators who implemented them. If we simply stand by and watch while those in government trample our rights, we condemn not only ourselves but our children to a life of servitude, serfdom, and misery. Rather, let us take a lesson from Captain John Parker at the Battle of Lexington. When the British commander ordered his militia to disarm and disperse, Captain John Parker gave the order, "Stand your ground. Do not fire unless fired upon, but if they mean to have war, let it begin here." Who in America today will stand their ground? Not to initiate violence, but to be prepared to defend themselves, even from their government. Who is willing to fight today when we can still do so at the ballot box and in the courtroom? Because if we won't stand now, what will our children say of us when they are forced to fight on the battlefield for the rights we so flagrantly threw away? Hey, this is good news, and I'll take good news when I can get it. While I, again, think the judge went through a lot of procedural hoops, he kept trying to find a way to place the opinions of judges above the law, he did come ultimately to the right answer. That is, lockdown, shutdown orders are unconstitutional. Now, while he says he declared these orders, these parts of the orders unconstitutional, what he did was issue an opinion. It is up to the people of the Commonwealth of Pennsylvania to hold their elected representatives accountable. It is time for them to remove Governor Wolf. It is time for them to remove those members of his executive agencies that enforce these illegal orders. And it's time to start finding people and charging them with crimes. And as I said, not just in Pennsylvania, but across this country, this is a perfect example of that tripwire, that straw that broke the camel's back, they just went too far, and it's time to rein them in. Now, we can do it. Again, I said we can do it at the ballot box. We can do it in the courts. Yes, we have an election coming up. We have a lot of people. We have a president. We have the entire House of Representatives. We have a third of the U.S. Senate. We have our state reps. We have our state senators. We have our governors. We have all these people. We need to look at them. Did they violate your rights? If so, it is time to find someone else. Forget about parties. I'm not worried about which group this person is a member of. If you're a Republican or a Democrat, I don't care. Until we start putting the supreme law of the land above our political parties, we will continue to be servants of those political parties. We'll be servants, we'll be slaves, we'll be serfs. Is that what we want for our children? Take the win. But let's take that win and use that to spread that win from the Commonwealth of Pennsylvania across the entire nation. Let's use this as the fuel to help remind us that we oversee the government. The government doesn't rule over us. They hold those positions because we have hired them. And it's time we start holding them accountable. In my mind, it's not merely enough for this court to say, you know what, Governor Wolf, that part of the order, the lockdown, shutdown, they're unconstitutional. And simply sit back and expect the governor to abide by that. No, it's time for him to be arrested. Arrested for violating his oath of office, arrested for depriving the rights of the citizens of his Commonwealth that are protected by the Constitution, arrested for violating the federal law and the supreme law of the land. Do I really think someone's going to show up with cuffs for Governor Wolf? I would be pleasantly surprised, but I don't think that's going to happen. I think it's not going to happen because I think the vast majority of the American citizens will simply go, hey, we won, we're done. We can't do that. We need to take this information and use it to make sure that this is not a one-and-done win. Because, as I said, I believe until these people start seeing criminal charges, they have no real reason to stop doing that. Let's face it, what's to really stop Governor Wolf from still implementing these orders? The judge isn't going to show up and throw handcuffs on him. You can whine and complain about what the court says. The court has no power. The judicial branch has no power. They're dependent on the executive branch to execute their opinions. What happens if Governor Wolf decides he's not gonna? It's up to we, the people, to take this judge's opinion and put it into action. Let's stop waiting for someone else to fix the problem for us. Let's stand up and start fixing the problem for ourselves. So I hope you found this educational. I hope you found it uplifting. Yeah, there's a lot of nonsense in there, but it was really nice to see a judge actually uphold the Constitution, if he kind of did it in a weird and judicial supremacist way. Head over to the website, constitutionstudy.com. Find this, share this. If you can, help support the podcast. Hit the donate button on the website. That will take you to a PayPal page. All of those donations go to keeping the Constitution Study online, keeping the podcast up and running, keeping the website up and running. Everything that you use is supported by those donations. I don't take a dime of it. It's all about keeping these messages available and spreading the word. Now, if you want to buy something on the store, I'd appreciate that as well. If you want to have me come speak to one of your groups, that would be wonderful. I'm trying to get out and about more. I've gone to a couple of gun shows, and I'm trying to go to a couple of other homeschooling events, other places where I can find Americans that are interested in protecting our rights and our liberties. So whether you can help financially or just help by spreading the word, join with the Constitution Study, sign up for the mailing list. Let's help take these rights and liberties forward. Let's learn to stand our ground. Let's not fire unless fired upon, but let's be willing to fight this fight now so that our children don't have to fight it later. Hopefully you found that something worthwhile, and you'll join me the next time on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from